Hello everybody and welcome to the channel Dr.Udaykumar. I represent Life Care Clinic and I am a HIV specialist. Uh, Today we are going to talk in English as the topic today that we have chosen is pertaining to a topic which should be available for each and every person including the doctor as well as the client. So today we are going to deal with right to confidentiality. So right to confidentiality is a topic that is not that much talked about but holds a crucial important point while maintaining a ideal doctor patient relationship. Doctor patient relationship starts from the day first of identifying the patient, and when the patient comes to you, he or she wants that you should have all the details for diagnosing, and after diagnosing the problem, then how that can be particularly treated, or the patient get rid of the problem and have a happy life. So patient often divulge information, and in that, mostly when coming to a HIV clinic, there are issues like sex related problems or HIV testing or HIV seropositivity, and this information which is obtained in the course of doctor patient relationship, that should be kept secret, and that should not be divulged until unless special circumstances arise, and this is called as confidentiality. Now what is confidentiality? It is a right or fundamental right of the doctor patient relationship, and it is a fiduciary nature. Right to privacy is also a fundamental right. Now the Supreme Court has considered the right to privacy in the case with R.R. Gopal v. State of Tamil Nadu, which says that the right to privacy is implicit in the right to life and liberty guaranteed to the citizen of this country by Article 32. It is the right to be let alone. A citizen has right to safeguard the privacy of his own, his family, marriage, procreation. There are various ways in that: motherhood, childbearing, and education, among other matters. So it is properly crystal clearly mentioned that the right to privacy is a fundamental right, and that should be given the importance. Now, as we go back in the early days when the Hippocrates, the father of medicine, who studied the medicine and made it possible to understand this in a professional way, he said the right of confidentiality has been recognized in the while practice medicine, and in the oath, Hippocratic oath also, it is given that whatever connection with my professional practice or not in connection with I see or hear in the life of men, which ought not to be spoken of abroad, I will not divulge, or as reckoning that all such shall be kept secret. That is, he was a Greek doctor, and whatever he practiced, he told that we should always have a connection with the patient, but professionally we should not divulge any information. So the right to confidentiality survives even after the doctor-patient relationship has ended. There are various ways, as if the patient has died or there is a change of doctor, still the right of confidentiality remains, and this has been explicitly incorporated in the International Code of Medical Ethics. With respect to the right to confidentiality, it states as under: a physician shall preserve absolute confidentiality on all he knows about his patient even after his patient has died. So death does not cut off the right to confidentiality. It remains there and remains till the doctor and patient are in connection. So there was an issue once that in an exhibition, the face of a patient was shown, and when the face of patient was shown, the exhibitee told that since the patient is no more, or the patient might not be aware of this, you need not to worry. But the issue remains that any organization or any relationship with a patient should not or is not allowed to have a photograph and put it on. This I have got it from internet, and the person here is showing that I am HIV positive. But when the person has to show that, the person should give a written consent. That's I am okay with it, and I will not divulge or otherwise the information with me is with my own consent. So that is how it is. So we should be always understand and respect the privacy of the patient, and unless the patient gives the permission in written consent, we should not divulge the information. So it should be remembered that confidentiality, there are various other aspects to this. Even when we are conducting any kind of research or experiment or drug trials on human subjects, there are various ethical codes, and the ethical guidelines for biomedical research on human subjects issued by the Indian Council of Medical Research lays down that there should be privacy, there should be confidentiality, and the identity and record of the human subjects of the research or experiment, they should be kept confidential, and they should not be disclosed without valid scientific and legal reasons. So essentially, we should have scientific consent in writing, as well as the subject concerned and the authority, and after that there should be there should be no discrimination, no stigmatization, having participated in the research or experiment. Even the Indian Medical Council Act 1956 provides for prescribing a code of medical ethics for those practicing modern system of medicine. It says that the registered medical practitioner shall not disclose the secrets of patient that has been learned in the exercise of his/her profession, except in the court of law under orders of the presiding judge. So only in the court of law we are allowed to speak only in front of the presiding judge. In circumstances where there is a serious and identified risk to a specific region and or community, and if there is a notified disease, in case of communication or notified disease, concerned public health authorities should be informed immediately. So these are the things we should be aware of. And even the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002, it further mentions that the confidences concerning individual or domestic life entrusted by the patient to a physician and defects and disposition of character of patient observed during the medical attendance should never be revealed unless there is a revelation is required by the laws of the state. Otherwise, there will be a big issue. Sometimes our physician, to protect a healthy person against a communicable disease to which he is about to be exposed, in such instance, the physician should act as he would wish another to act toward one of his own family in the like circumstances. So, in the court of law, or if the patient or may have reason to increase the infection to other person, the physician can intervene. So the court of law and the physician are the both important pillars in which we should understand and work up, so that we can give the best possible way to the human society. So the confidential medical examination it should not be pulled off to anybody, and HIV testing and all other things are done only after written consent. Most of the time people do not take a written consent, that can be the issue. Before medical examination or before testing a patient for HIV, the patient should be counseled. Lot of times people put away the counseling thing, and the patient does not understand the benefits or the risk involved when the patient turns HIV positive or the report comes positive. So that should be understood, and this point of understanding may help the patient to work in a proper way. So when can there be a breach of confidentiality? The confidentiality can be breached under certain circumstances, like if the public interest so requires, which is under only limited circumstances only. Secondly, if it is legally enforceable duty, or there is a consent of the patient. Fourthly, in compliance with the court order, and lastly, in the best interest of the patient. So these are only 5 things which are available if we have to have a breach of confidentiality. There should be no other reasons other than this. So let's see in details what about the public interest. Suppose if a patient is suffering from an infectious disease and poses a risk of transmission to the public at large or to a specific person, then the doctor may breach the confidentiality. So, but while doing, the doctor should be very careful in deciding whom to divulge the information. Even when the General Medical Council of Great Britain on HIV infection AIDS, which has stated that the person who might be positive and the doctor want to disclose the diagnosis to third party other than a healthcare professional, the council think that the only ground for this are when there is a serious and identifiable risk to a specific person who, if not so informed, would be exposed to infection. The doctor may consider it in duty to ensure own wishes. So we should work in a way in which the larger benefit of the society should be looked on. There are two more points which are also emphasized, that if there is serious and identifiable risk to a specific person, or if a person is not informed, he would be exposed to infection, then there should be the way to may have a breach in the confidentiality. So there is an example of a patient, of a doctor who was accompanying a patient in a hospital, and it was in UK, and the patient required blood, so Dr. Y donated blood, and it was discovered that patient Y was seropositive for HIV infection, and therefore this information was communicated to the fiancé, which led to the calling of this engagement. So this particular kind of thing happened when the Dr. Y appealed to the Supreme Court and of the National Commission, and in which there was a issue. The questions were that whether such disclosure of information can be made, and if yes, to what extent. So it was held by the court that the right to privacy exists, and such right is so absolute and can be restricted for protection of health of others. Therefore, the disclosure of the fact, rule of confidentiality to this right or his right of privacy. This was because Dr. Y's fiancé was indeed saved in time by such disclosure from getting infected with HIV following consummation of marriage. These are some examples that might have happened in the past, but today people can have HIV negative child even if the partner is positive, and that can be worked out. Now also, if there is legally enforceable duty, as in the case of notifiable diseases, we know that the authority may be furnished with the relevant information and regarding patient when there is a legally enforceable duty. It is to be noted that the information be given to the appropriate authority only and not anybody else. So that's the legal way. Consent of the patient, yes, if the patient consents to disclosure of information regarding her medical problems, then the confidentiality may be breached. But I would like to underline it that the consent should be a written consent. Otherwise, there can be issue in the future. Fourthly, in the compliance with the court order or under order of the presiding judge of the court, doctor may breach confidentiality. Such release of information has to be in accordance with the order of the court and to the extent ordered by the court. And lastly, in the best interest of the patient. Suppose your patient confides to a physician and then he is contemplating suicide. To protect the interest of the patient, the information can be passed to the third parties who are interested in the welfare of the patient. So these are the 5 things we should know, and in the good clinical practice, we always go with the best interest of the patient. We have knowing what is there was a word called fiduciary character. So you can go to the fiduciary character means a person who is a duty of care or duty of loyalty, and he can help in a good interest of the patient. So the last concluding points for this particular topic is that the doctor-patient relationship is of fiduciary character that is based on trust, and this requirement of trust mandates that the doctor maintains confidentiality. The right to privacy and confidentiality continues even after the death of the patient. So these points are indeed needed for the doctors as well as patients to know their rights and issue. I will continue to upload more such points in the next videos. If you think English is comfortable, I will continue in the English, or also if you want that to have this in Marathi, I will make up in a Marathi. So as you know, the information that can be divulged to other patient under certain circumstances is restricted to those to whom such information can be divulged and none else. So everything should be given to the person who has the acceptance and interest, and we should not be given to everybody. This is my number, 9145232616. If you have any need of any opinion, or if you need any consultation, you can contact me. This is a paid consultation, and I am experienced in treating HIV patients from past 12 years. If any issue, you can contact me. We also provide other services for HIV positive people all over India. My address, which is at Anand Plaza, Amarpet Hotel, Jalna Road, Aurangabad. We have closed on Sunday, and the rest weekdays we are open from morning 9 to evening 5 o'clock. Thank you very much. Please like, share. Please also let me know in the comment section if you want to in English, other lectures in English, or should I continue in Marathi language. Thank you very much.